Somebody mind closing the back door, please? Thank you. This is house number 180110. Good morning. Montana Environmental Center versus Western Energy and the Department of Environmental Quality. Are council ready to proceed? So, Ms. Bowers, I think you're up first.
Good morning, Chief Justice McGrath and Justices of the Supreme Court. I'm Kirsten Bowers, representing Department of Environmental Quality, with co-counsel Ed Hayes, and also at council table are John Martin and Vicki Marcus, representing Western Energy Company. The district court committed 2 errors in invalidating DEQ's renewal of the Montana Pollutant Discharge Elimination System permit issued to Western Energy Company, authorizing discharges from the Rosebud coal mine near Colstrip, Montana. First, the district court failed to give effect to Administrative Rule of Montana 1730-637-4 in determining that DEQ reclassified the ephemeral drainages at the mine. Second, the district court erred by ignoring substantial evidence in the administrative record that supported DEQ's representative sampling protocol for wet weather discharges from the mine. Under the Montana Water Quality Act, the Board of Environmental Review must establish classification of all state waters in accordance with their present and future most beneficial uses. The board has established water use classifications by watershed. The classifications for the Yellowstone River drainage are set forth in ARM 1730-611. With some exceptions, state waters in the Yellowstone River drainage from the Billings water supply all the way to the North Dakota state line are designated as Class C3 waters. At the time the Class C3 designation was established in 1980, the board also adopted ARM 1730-637 sub 4, and 637-4 provides alternative treatment requirements and water quality standards that specifically apply to discharges to ephemeral drainages regardless of their classification. Ephemeral drainages are streams that flow only in direct response to precipitation or melting snow and whose channel bottom is always above the local water table. The Rosebud mine is located within the Yellowstone River drainage between the Billings water supply and the North Dakota state line, and thus its drainages are classified as C3. The 2012 renewal of the MPDES permit authorized discharges from 151 point sources at the mine. Each of these point sources is associated with a settling pond to which Western Energy places collected stormwater and groundwater that it extracts to depress the water table and allow strip mining. There are discharges from these point sources only in the rare instance that a precipitation event exceeds the design capacity of the settling pond and overtops the impoundment, or the mine plans a discharge to manage pond capacity. The design capacity of the settling ponds is based on a 10-year, 24-hour precipitation event, and in most years, discharges are rare. Because the settling ponds are located in ephemeral drainages, DEQ applied the alternative treatment requirements and water quality standards for discharges to ephemeral drainages that are set forth in 637-4. However, the state waters at the Rosebud mine remain classified as C3 waters.
Ms. Bowers, I have a question about the difference between the classification and what you're calling the alternative treatment requirements. So it seems that this is really the heart of this case, the interrelationship between that classification and subsection 4 of 1730-637. And what you said here today and argued in your brief is that the department can apply subsection 4 to an ephemeral drainage even though it's within a general basin C3 classification. But the rule doesn't specifically say that. And what I'm wondering is how these rules fit together, and if because none of the, as I read the rules, none of the stream classifications for the basins include any E1 or E2 classifications, and yet there is a separate classification for ephemeral streams. So how do those fit together, and how, in the language of this rule, does the department take away that you can apply these, what you're calling alternative treatment requirements, in something that's not classified as an E1 or E2 stream?
Right. The waters are classified C3, but the language of 637 sub 4 says that the general prohibitions and treatment standards apply, but not specific water quality standards of 1730-620 through 1730-629, and those are the water quality standards that apply to a C3.
Right, but why doesn't that just apply? It says treatment requirements for discharges to ephemeral streams, and under 1730-615, it says that water use classification for waters in ephemeral streams are to be classified as E1.
Yeah. In 2002, the board did adopt the E classes, which include classifications for ephemeral drainages, E1 and E2, actually E1 through E5, but E1 and E2 could possibly apply to this type of ephemeral drainage. And that classification system would require the Board of Environmental Review to undertake rulemaking and conduct a use attainability analysis. But DEQ also has a second way to treat ephemeral drainages, and that is with its what we call the Ephemeral Rule 637 sub 4. And in that rule, the department has the discretion to apply alternative treatment requirements to a drainage that is hydrologically ephemeral, not classified as E1 or E2.
Why don't you repeat that? Go through that one more time.
Okay, under the existing rules, reading all the rules together, the department has two different ways to treat ephemeral drainages. One is to recognize the hydrologic condition of a drainage as ephemeral and apply the alternative treatment requirements in 637 sub 4. That does not change the use classification. The second way is the Board of Environmental Review could undertake a rulemaking and change the use classification to an E1 or an E2, for example. And that change would permanently remove uses. What DEQ is doing by applying its ephemeral rule does not permanently remove the uses. They're still C3 uses. And they're protected through the minimum treatment requirements, operation requirements, and prohibitions that are described in 637-4, but not the specific numeric standards that are in 1730-629.
Are there any examples of an E1 or E2 classification that exists now?
The board has not reclassified any state waters into the E class at this point in time.
So what's the purpose of it? I mean, if in a basin, what you're saying is that the ephemeral drainages don't have to be classified, yet they all eventually lead to in this case, the Yellowstone, right? What's the purpose of it?
Well, an ephemeral drainage has no water except when there's precipitation, and in that event, it would only have water for a very limited period of time. These drainages look like prairie grass. They don't have wetland plants. They don't hold pools of water. So if there is a precipitation event, the drainage would have water for a short period of time. And yes, you're correct. Ephemeral drainages do lead to intermittent and then to perennial waters. But The specific water quality standards in 1730-629 are designed to protect human health, and they're based on exposure to water for a lifetime, for example, which isn't going to happen in an ephemeral drainage. And you asked what the purpose is of having the E-class, and that would be used if the board received evidence and felt it was proper to permanently remove a use, aquatic life, for example. Because the E-class is E1, we would not protect aquatic life. They're mostly E1 and E2 are for agriculture purposes, wildlife, and non-contact recreation.
Well, you said that the alternative treatment requirements were imposed by the department here based upon its determination or consideration of this water as ephemeral. And that is different than classification by the board of the waters as ephemeral. I understand you consider them different. But is the definition the same? I mean, is this a term ephemeral mean the same thing in both contexts?
I think the definition is a little bit different. The definition of hydrologic ephemeral is defined in the rules, and that means a water body that just responds to precipitation and is not influenced by groundwater. A water body that's reclassified into one of the E-classes is most likely ephemeral, but it also, we know that the uses aren't there. There's no aquatic life, and so the board would be willing to take the next step and permanently remove those uses.
Where are those definitions?
The definition of ephemeral is in 1730-602.
And there's a different definition of hydrologically ephemeral?
That definition is hydrologically ephemeral.
I guess I'm confused then by your answer to Justice Rice's question, because you said they were not the same.
Well, I guess just to clarify, the E-class would be applied to a drainage that is ephemeral. But there are also ponds that could go into the E-class. There are other water body types that could go into the E-classes E1 through E5. E1 and E2 would probably apply to an ephemeral drainage.
So what is the practical distinction between the department treating a drainage as ephemeral under 1736-37 sub 4 and the board reclassifying a drainage as E1 or E2?
The practical distinction is that under 637 sub 4, the C3 classification is not changed. And the C3 uses are still protected, but they're protected by the alternative treatment standards that are in 637 sub 4, which prohibit discharges of harmful, toxic substances that would harm human health, aquatic life.
If the board designated the drainage as an ephemeral drainage, then there wouldn't even be the alternative treatment standards?
If the board designated as an E1, for example, there would be specific uses that apply to the E1 class, and then there would be water quality standards to protect those uses, but it wouldn't include protecting aquatic life, for example.
So in the prior permit, were you doing the same thing? Did DEQ make the hydrologically ephemeral unilateral classification?
Yes, Justice. In the 1999 permit, the waters were treated as ephemeral.
And how do we know that?
The 1999 permit is in the administrative record.
What's the practical implication of, as I understand the district court's ruling, it would require the department to reclassify all of these ephemeral drainages as E?
Well, the district court's ruling was that our use of 637 sub 4 was a reclassification, and that's not correct. We didn't reclassify the waters. Just to talk a little bit about the representative sampling, the second issue. The district court also erroneously determined that DEQ did not provide sufficient analysis to require representative monitoring. But the 2012 permit actually if you look at the permit as a whole and the chart that's table FS7-37 on page 1449 of the record summarizes the representative monitoring outfall locations, and it shows that DEQ selected outfalls from 4 active mine areas and selected monitoring locations that represent both alkaline mine drainage and coal preparation. Those terms are defined by the federal effluent limit guidelines, and the district court ignored substantial evidence in the record supporting DEQ's selection of representative monitoring outfalls. And the record provides a sufficient basis for selection of the outfalls. DEQ chose approximately 20% of active outfalls at the mine for representative monitoring of precipitation-driven discharges. And the reason DEQ determined that at least 20% of the outfalls should be sampled during wet weather events was to be consistent with a similar permit issued by the US EPA to the Black Mesa mine on the Navajo Reservation in Arizona. The department, in fact, went a step further than the 20% sampling protocol approved by EPA for the Black Mesa mine and required installation of automated sampling equipment at representative monitoring locations to ensure flow measurement and sample collection during wet weather events.
Say that again. They went beyond the 20%?
They went beyond the 20% that was imposed by the US EPA at the Black Mesa mine by requiring installation of sampling equipment at the representative outfalls.
So what makes this site similar to the Black Mesa? I mean, why is that our measuring stick?
Well, they're similar coal mines. They're large surface coal mines with similar numerous outfalls.
But one of the other variables in there are the precipitation events. I mean, I don't know. I'm not trying to be glib here. I'm assuming we have more precipitation events than Arizona.
Yeah.
Is that accounted for?
Well, I think you might be right. The Rosebud mine might be a little bit wetter, but the precipitation is fairly flashy and localized, and the permit writer did try hard to select outfalls from the 4 active areas at the mine, and also to representatively sample the alkaline mine drainage areas and the coal preparation areas.
So, give me that chart again. I was looking for that, or we were looking for that.
It's table FS-37. It's on page 1449 of the administrative record.
It's
FS-37 on page 1449 of the record. So, looks like my time is up. DEQ requests that the court uphold DEQ's decision to renew the permit and vacate the district court's memorandum and order.
Mr. Martin.
May it please the court. My name is John Martin, and I represent Western Energy in this case. And I should add that I'm accompanied by my colleague, Vicki Marcus, in this argument. I'd like to, if I can, build on some of the responses that were provided by Ms. Bowers, perhaps elaborate on some of the questions that were asked by Justice Baker, Justice Gustafson, and the Chief Justice. First, I think the fundamental question that was asked, and it was also, I think, a query by Justice Rice, is, in essence, what's the purpose of the E1 through E4 standards if, in fact, you have this pre-existing exemption, if you will, from the C3 standards? And I think there are 2 points to be made here. Number one, the C3 uses are different from the uses that would ordinarily be attendant to an ephemeral stream. Ephemeral streams are dry drainages, and uses such as swimming, fish propagation, are not common in dry stream beds. So as a policy matter, it makes sense not to apply the standards that are traditionally applied to the C3 standards for perennial and intermittent streams. Let me also add, just in response to the practical implications question that Justice Baker had, we have, as I think anyone who has been around eastern Montana, thousands of dry drainages from Billings to North Dakota, which is the area of the C3 use classification. If we were to lose the ability to use that exemption, if you will, that would create some very difficult circumstances for DEQ. The distinction between a use classification and what I'll call the 637-4 exemption from C3 standards is that we don't have to go through a use attainability analysis. We're not required to go through the board. We don't have to go through what's necessary for what is perhaps a permanent designation, a change in the classification. So that gets me to the second point, flexibility. What we have with the provision in 637-4 is a flexible approach that can be changed. Once every 5 years, these permits are readdressed by DEQ. And so if the character of a stream changes over the course of a 5-year period of time, then DEQ has the prerogative to say, gosh, we recognize that in this instance, this particular reach of this particular stream is no longer ephemeral. It's not just a dry stream bed. It's not just a gully. Instead, now it is perhaps an intermittent stream. It is perhaps a perennial stream. And now is the time for us to adjust this in our approach to the individual permit. And perhaps that's what we have here. We, after all, did recognize, and I recognize, by the way, that this is unclear in the record below, but DEQ and Western Energy recognized after 2014 that a portion of East Fork Armells Creek should properly be classified as intermittent. And so the agency could go back and they could say, well, we didn't change the overall use classification. Instead, we used this provision, 637-4, to adjust the limits, if you will, and accommodate the reality that, in fact, this was an ephemeral stream. Let me add just a little bit by way of the history of this provision. You know from the briefing that the C3 classification and the exemption that's at issue in this instance were actually promulgated at the same time, that is to say in 1980. So for nearly 40 years, the state of Montana has been treating ephemeral streams in this fashion. This is not something that's new. There are perhaps hundreds, if not thousands, of permits that have been built upon this provision that allows the general standards to apply as opposed to the specific ones that apply to the use classification C3. That leads me to a point that I think has been obfuscated in the briefing. I don't think it's entirely clear from some of the argumentation that we're receiving from the appellees in this case that there are protections afforded for these ephemeral streams when we employ that language in 637-4. What happens with 637-4 is that the general prohibitions apply. There is a specific provision in 637-1D that prohibits the discharge of toxics and harmful substances. Anything that's toxic or harmful to a human, animal, plant, or aquatic life is prohibited by that general provision. And that's what happens when DEQ takes advantage of this provision that, again, has been in place since 1980.
Mr. Martin, can you, go ahead. Can you discuss I'm sorry,
No, go ahead.
can you discuss that in the context of the appropriate standard of review and what the district court did?
I think the appropriate standard of review in this instance was great deference to DEQ. This is an application of a regulation. It is something that is determined by the application of the expertise of DEQ. DEQ looked at their regulation, first they construed it, and then they made a judgment call. They made a decision as to whether or not they should go about having, for example, a permanent reclassification, which could create, shall I say, a lesser level of protection than would exist under the current circumstances. They made that determination. That's a technical judgment, Your Honor, and properly they're entitled to high deference.
Mr. Martin, if you're finished with your answer, are you done? I want to get back to what you were just talking about in the difference between the classification and the exemption and the applicability of other provisions of 637. So as I read the classification standards for an E1, for example, it says the narrative standards in 1730, 637, 1D, and 2 that pertain to aquatic life do not apply. So if the drainage is classified, then what you're saying is there are less stringent requirements for that ephemeral stream than if the department simply recognizes it as hydrologically ephemeral but otherwise still within that C3 classification?
And that's a very good question. Let me respond by saying yes, to the extent that the aquatic life would not be protected as it is under the general provisions. So to that extent, if you reclassify, there is a lesser level of protection. But let me qualify that to some degree. Because there is flexibility conferred by that provision, 637.4, then DEQ has the capacity to adjust its limits in a particular permit so that, for example, it might have standards that don't protect for a swimming use for this dry gully. That's a sensible conclusion. So I don't want to go too far when I say there would be lesser protections, but there is no obligation if it were reclassified to protect aquatic life.
Going back to just kind of picking up on that, so if something were reclassified, if you're using the reclassification instead of the exemption and it's within the C3 basin, using your example of what happened here with that portion of, the East Fork of Armels Creek, when there was a portion that was determined, I think, that it ran below the water table for part of it. If this had been reclassified, they would have, in order to then go back, they would have to go through the whole process of reclassification instead of just making the adjustment pursuant to 637.4.
Yes, Your Honor. Justice Shea, you understand perfectly what DEQ is confronting.
That part.
I have to say these are not the easiest regulations to make one's way through. I'd like to talk, if I can, about an issue that was raised by our colleagues at TU and to a lesser extent by the Clark Fork Coalition. They make the point that, what happens in a circumstance where you have an ephemeral drainage followed by an intermittent portion of the stream and then a perennial portion of the stream? Isn't it true that what you discharge in the ephemeral drainage can have an effect on the intermittent portion and or the perennial portion? And at least we at Western Energy say, yes, that could certainly be something that DEQ has to account for. And I think the provisions, the general prohibitions, account for that because it specifically says anything that's toxic or harmful to animals or fish is something that is prohibited. So if we're in a situation where DEQ makes the technical judgment that this ephemeral drainage will have an effect on the intermittent portion and or the perennial portion of that stream, then DEQ can account for that by providing for a more restrictive limit. So that flexibility is built into this general prohibition, and as I say, in many circumstances, it affords more protection rather than less, and obviously it's more cumbersome. Let me add, Justice Shea, you make the point that one would have to go through this process. It's not an easy process. A use attainability analysis or just a reclassification means that we have to go through a process that may take multiple years to establish the data and would require us to go through the board, and the board would be encumbered with an administrative change that frankly would not be the easiest thing in the world. And by contrast, if we can employ this flexible provision, the general prohibitions, with every permit that comes up on a 5-year basis, DEQ can look down and say, okay, this portion of the stream appears to be ephemeral, so we're going to adjust the limits to accommodate that ephemeral portion of the stream. We're not going to protect for uses that include, for example, swimming and fish propagation. Instead, what we'll do is we'll establish limits that protect, for example, the intermittent portion of the stream that's further downstream, and ones that are the result of the technology. One last point before I sit down, and that is that many of the issues that would attend other permits don't apply in this circumstance. What is uncontroverted in the record is that the discharges here are actually cleaner than the water that ordinarily, or periodically I should say, flows through these dry stream beds. It's uncontroverted. Dr. Schaefer provided an affidavit, and it's clear that we actually have a lower level of contaminants that come from the discharges at the mine than what you would find naturally in these dry stream beds. You might ask why, and to the pointy-headed lawyer here, my understanding is that we have these sedimentation ponds that collect the water at the mine. The total suspended solids are settled out, and only after this settling process occurs are they occasionally discharged as a result of precipitation. So it's not surprising that at least in this particular case, we actually have discharges that are cleaner than the water that flows through these gullies on occasion. Unless the court has questions of me, I'll reserve the balance of my time for rebuttal. Thanks very much.
Mr. Hernandez.
May it please the Court, Shiloh Hernandez for MEIC and the Sierra Club. With me is Andrew Gorder from the Clark Fork Coalition. I will be ceding 7 minutes of my argument to Andrew. Your Honors, cowboy poet Wally McGray from Coalstrip wrote about things of intrinsic worth. Montana's waters have intrinsic worth. It's the purpose of the Clean Water Act and the Montana Water Quality Act to protect and restore the integrity of Montana's waters. Here, DEQ's discharge permit for the Rosebud Strip Mine did not restore or protect the integrity of Montana's waters. The district court's decision was well supported both in law and in fact, and this court should affirm. I'd like to spend my time this morning addressing 2 issues. First, the issue of DEQ's unlawful reclassification or weakening of the applicable water quality standards for East Fork Carmels Creek and the other receiving waters, and second, DEQ's unlawful monitoring scheme. First, water quality standards. DEQ's decision here to weaken the applicable water quality standards was unlawful for two reasons. First, DEQ did not follow the proper procedure for modifying or weakening water quality standards. And second, DEQ did not compile and analyze the relevant information, meaning the information in its own files. To my first point, if a state wishes to weaken water quality standards, it must prepare a scientific study called a use attainability analysis. And in Montana, if we want to change, modify, or alter the water quality standards for a creek, that is the province of the Board of Environmental Review, which is a citizen board subject to public oversight, and the process that they use to do this has to be scientifically supported. Here, DEQ admits that it exempted the receiving waters from the specific water quality standards for C3 waters. C3 waters have a whole suite of applicable numeric water quality standards, including limitations on the amount of toxic heavy metal pollution that can be discharged into a stream. There's no dispute that DEQ here removed those protections. They modified the applicable water quality standards, and they weakened them. DEQ also admits that it did not prepare a use attainability analysis, and it did not ask the Board of Environmental Review to change the water classification. As such, DEQ's decision to modify the applicable water quality standards was unlawful.
So what about the argument that they didn't reclassify it? They used an exemption that's provided in the rules, and the general rules covering C3 waters still are still available to protect water under this permit.
That argument doesn't work for a number of reasons, Your Honor. First, they're saying that the waters are still C3 waters. We didn't change anything, but they gutted the C3 rules. They took all the specific protections for C3 waters and removed them, every single one of the C3 protections, and removed them. And so their argument is, we didn't go through the procedure with the Board of Environmental Review to remove these protections. Therefore, what we did is lawful. But that argument can't possibly succeed. I think the case that most clearly explains this is the Florida Public Interest Research Group case from the Fifth Circuit, where they said if the effect of the decision is to weaken water quality standards, then the state has to follow the appropriate procedure, because otherwise they could just use a word game. They could not follow the procedure and say, well, since we didn't follow the procedure, we didn't change the water quality standards. Here, Montana's law is very clear. All the sections I'm going to refer to begin with ARM 17.30. something. But Section 606 says that any modification or change in a water quality standard must be done by BER. There's no question. They could argue whether or not they changed the classification. There's no question that they modified the C3 water quality standard because they removed all the C3 protections.
So, counsel, what effect would you give 637 subsection 4?
637.4 still operates. It can operate as it should, but before they do that, since it affects a change in water quality standards, they have to follow the procedure for changing water quality standards to ephemeral to weaken the water quality standards. And Section 615.2 spells out how they do that. In 2002, the Board of Environmental Review addressed this issue and said, we need to deal with ephemeral waters. Our scheme as it is doesn't work. This is how it works. If you want to weaken the protections for an ephemeral stream, you have to do a use attainability analysis, and we have to change it. So once they've done that, then, as Justice Baker, you suggested, then 637.4 applies. It's ephemeral stream. They've classified it as ephemeral. The 637.4 exemptions apply.
So it's your position then that once the board in 2002 adopted these E classifications, at that point 637.4 became applicable only to an ephemeral stream that was so classified. Is that what I'm understanding your position?
Yes, but it's a little bit more nuanced than that, but that's the essence of it. In the E exemption, 637.4, 4 was adopted in 1980. In 1983, EPA promulgated rules for changing classifications and provided for the use sustainability analysis provision. When BER addressed this issue in 2002, they said, we've got to do this so that we can effectively use, we can have lesser protections for ephemeral waters that comply with the Clean Water Act. They say in their response to comments, the 2002 rule, even if we didn't do this rule, the use sustainability analysis requirement would still apply because it's a federal provision that applies to state programs. And that provision, and I think that's key because I think both of my friends on the other side don't give it any attention. It's that the federal rule, 40 CFR 131.10 sub J, which has been adopted in Montana under 619, it says that if a state is going to change uses or create a subclass of uses of waters with less stringent protections, it must do a UAA. And it was in recognition of that the Board of Environmental Review in 2002 changed the rules. And if I can dwell on this point for just 1 second, Your Honor, Mr. Martin, my friend, the first point of his argument this morning, he said, what we want to do with these waters is we want to say that they're ephemeral. They're C3 waters, but they're ephemeral waters, so they're entitled to a little less protection. Their water aquatic life here isn't the same as in other C3 waters, so we're going to protect it a little bit less. Well, when you do that, that's precisely when you have to do a use attainability analysis because they're creating a subclass of C3 waters. They're saying C3 waters are everywhere, but this subclass of them is getting less protection, less stringent protection. And for that, they have to do a UAA. And because that federal requirement and state requirement mandates a scientific analysis before weakening the protections, that's why the board passed the E classifications in 2002. And Justice Baker and Justice Shea and Rice, you asked questions that seem to suggest, well, what remains of the E classifications if DEQ's position is upheld? And the answer is that they're a dead letter. Here, DEQ admits in its reply brief that it has never applied the E classifications. They've been on the books for almost 2 decades now, and they've never used them. And the reason they haven't used them is because they've got this loophole. They're exploiting 6374 in a way that entirely undermines all the E classifications. And on this, Justice McKinnon, I'd just like to respond to your query about the appropriate standard of review. DEQ is asking for deference in this. And the court has said in the Clark 4 cases that there are 3 circumstances where the department doesn't get deference. First, if their interpretation is incorrect. We submit that it is. Second, if their interpretation of a rule is contrary to the intent of the statute. Here it plainly is. The Clean Water Act and the Montana Water Quality Act's intent is to protect the integrity of our waters. And here, they're removing the necessary protections and allowing unlimited discharge of pollution, heavy metal toxic pollution. Third, the court also says that it won't afford deference if the department's analysis is unreasonable. And then there's a fourth situation that's not entirely, hasn't been expressly announced, but is clear in the Clark Fork 1 decision. There was a question of interpretation of a non-degradation rule that the Board of Environmental Review had promulgated. DEQ was offering interpretation. The court noted that DEQ's interpretation of that rule conflicted with the interpretation of BER, who promulgated the rule. In that circumstance, the court said, we think BER's interpretation of the rule is the controlling interpretation. DEQ's interpretation conflicts with it. BER promulgated the rule. They're the rulemaking body. We're going to defer to them. And here, BER was very clear in 2002 when it promulgated the E classes. They said, without these E classes and without this formal classification process, we have to treat ephemeral waters under the classification that they were given when they were classified. And they were classified by basin. So they said, since we understand that ephemeral waters might be subject to, might not need the same protections, but before we can remove their protections, we have to have a process. And that's what we're doing. We're creating this process for classifying them and under the classifications for removing the rules.
So, counsel, is there, just again as kind of a practical matter, is there a dispute? I wasn't clear on this from your position, that the waters aside from the East Fork of Armels Creek that was determined to be partially not an ephemeral stream, is there any dispute that these other waters would actually or could actually be reclassified as ephemeral?
Yes, there absolutely is, Your Honor, and that was the second basis for the district court's ruling on this. District court said in the separate review for arbitrary and capricious decision-making, this court in Clark Fork 1 said you have to compile the relevant information, you have to analyze it. Here the administrative record has zero compilation or analysis of information with respect to the actual quality of these streams. In discovery, we looked into DEQ's files, and we found, much to our surprise, that many of the receiving waters were determined by DEQ not, in fact, to be ephemeral. They said portions of Lee Cooley are not ephemeral but intermittent. There are portions of East Fork Armels Creek, a 2-mile stretch above what they've reclassified, which their prior report said was not ephemeral. There are portions of Pony Creek and Spring Creek that are not ephemeral. And that was the second big problem here. DEQ didn't even look in its own files, which showed that many of the waters here are not ephemeral. And I think that point, Justice Shea, underscores the value of use attainability analysis. It requires a scientific study of the waters before the state can remove important protections like limits on heavy metal toxic pollutants.
Just to get back to the point that you were making about deference to the department versus the board. And so you said it's the board's rule, and the board decided that there should be these E classifications. But that was almost 20 years ago, and the board has not made any E classifications. So what are we to make of the board's, I guess, emphasis on the classification if it's never used it?
I think a few points, Your Honor. The board is a citizens board, and they respond to general petitions for rulemaking. If the department wants a petition for rulemaking, they can. If a party wants it, they can. They have limited capacity as a 5-member citizen board to say, well, I think that a portion of Rosebud Creek up in the headwaters is ephemeral, let's change that. I think, Justice Baker, that there's a good response to this in the board's response to comments in its 2002 rulemaking. There, a commenter said, wait a second, DEQ is going to be overrun, the board's going to be overrun with these use attainability analyses, it's going to be way too expensive. The board said, no, what we'll do is we'll prioritize doing UAAs to respond to permits. If someone's seeking a permit in a water that may be ephemeral, bring it to us, and we'll respond appropriately. So that's the reason that the board hasn't done it. They said, we're going to wait until the department comes to us to make this administratively manageable. The department hasn't done it, though, because they see this 6374 loophole. And on that point, Justice Baker, I want to respond to the suggestion of my friend Mr. Martin that somehow the UAA requirement would result in thousands of permits being overturned in this big administrative nightmare. It's just not the case. Prior to this argument, we looked at how many permits DEQ has. DEQ has issued, in the entire state of Montana, 35 major discharge permits. 35, that's it. There are a little over 100 minor discharge permits. So total, the state of Montana has about 150 permits. I think it's very unlikely that all of them would require a UAA because they're all discharging to ephemeral streams. And the second point that Mr. Martin made is that a UAA process is this onerous process that makes this permanent change in water quality, and that's just not accurate. I'd like to direct the court to a case that we cited in our briefs, which was Kansas Natural Resources Council. It's a federal decision from Kansas, very similar question. Kansas didn't want to protect uses of some prairie streams, much like here. The federal court said, hey, you have to do UAA, and they did it. They noted there, though, that from the time the court's first ruling said, Kansas, you must go forth and do use attainability analyses if you want to weaken water quality protections, to the second decision, which was 2 years later, the Kansas DEQ managed to complete 200 use attainability analyses. Kansas, I think, has roughly the same amount of state resources as the state of Montana. They were able to do 200 UAAs in a single year. The point there, Your Honors, is that EPA has guidance on UAAs. It doesn't have to be a very in-depth process. Here, DEQ simply has to look into its own files because they've been studying East Fork Armels Creek for decades. And for decades, they've concluded, Justice Shea, that many portions of these waters are not, in fact, ephemeral.
Leaving the practical for a moment and back to the regulation, my reading is that classification process is a basin-by-basin determination. Areas of water, basins of water are classified, and that the classification system is not designed to be used permit by permit in application to individual circumstances. Your description of the process would seem to conflict with it.
Yes, Justice Rice, that's kind of accurate, kind of not. The Clean Water Act, Section 303, required states in 1972 to establish classifications for every water body in their state, which was a huge administrative task. So what many states did, Montana, like California in the California sanitation case that I cited, is that for administrative ease, they classified by whole basins. That's why we have this classification of Yellowstone River from Billings to North Dakota. They said, it's all C3. And then we're going to go and make more nuanced analyses as we need to. But that was just because of the mandate of the Clean Water Act. There's nothing in the Clean Water Act that doesn't allow the state to go back and say, this segment of East Fork Carmels Creek above this portion of the mine is and has always been ephemeral, and therefore we're going to change it. There's no necessary conflict there, Justice Rice. It's just a product of the requirement of the Clean Water Act to establish classifications. But it's an important point because the Clean Water Act said states, you have to classify all your waters. And so the states did. And there's no question they said, these waters are C3 waters, and that's how it's going to be. And they said, if we need to go back and make more detailed tinkering with it, we can, but we'll deal with that in the future. And with e-waters, e-classifications, the board said, just go back and do it as you need by each permit, which is what they could do here. One final point on this, Your Honor, is with respect to the suggestion that they try and say that there's separate value in E-classes in 6374 because the E-classes provide this permanent classification, whereas 6374 is this more flexible approach. But that's just not correct. There's nothing in the E-classes that prevents them from being reclassified. The board could say, we thought it was E, but it's not, and so we're going to change it. 2 points I'd like to make on this is that DEQ's suggestion of flexibility really seems like the suggestion to make unsupported decisions, which they did here. They said, it's all ephemeral. We said, wait a second, is it? In Discovery, we propounded Discovery and said, are all the waters, do you contend that they're all ephemeral? And they said, actually, oops, we looked and they're not. And then we found more Discovery that indicated even more than more. So the scientific study part of the UAA is supporting rational, reasoned, good decision-making. So that's, I think, unimpeachable. The suggestion that it can't be changed is also just not accurate. It can be changed.
Could you address Mr. Martin's point that allowing this flexible standard versus classification actually can provide more protection because if it's classified, some of the provisions of 637 don't apply?
I think as an initial matter, that is, it's just not lawful, his suggestion, because any reduction in protections under the use attainability analysis regulations requires a UAA. So if they're just going to reduce the protections, that first off requires a UAA. They're creating this subclass of C3E waters that are getting less protection. That requires a UAA. So that's just the law. And then the second point about, well, this actually provides more protection, I'd like to address that straight on. It simply it doesn't make sense here. Here, DEQ performed what they call a reasonable potential analysis. They said, before issuing a permit, they analyzed the permit, and they say, what's the potential based on their past discharges that they're going to violate water quality standards? And they said, we looked at that, they analyzed it, they did a good analysis, and they said, we think the continued discharges are going to cause violations of 3 toxic heavy metals water quality standards: aluminum, iron, and selenium. And they said, we're going to impose these standards. Western Energy pushed back, and they removed them. So before, they would have had tight limits on these heavy metal pollutions. Now, they don't. And here, I want to note that in the record, in the briefing, my friends on the other side, Western Energy and DEQ, decided to point this court to more recent information that wasn't for the district court about the status of these waters from 2016 and 2018. They said, look at our new reports. We decided that actually the mine didn't obliterate part of the creek. There's something else there. What they don't say is that the section right below the mine, section 110 of East Fork Carmels Creek, has just been determined by DEQ to be impaired and not supporting aquatic life for iron and aluminum, the very toxic heavy metals the DEQ decided not to regulate in this permit based on 6374. So the idea that somehow this is providing more protections is wrong. The creek's now impaired for those very pollutants. And then
Is that in the record?
it's not in the record. It wasn't before the district court, but my friends on the other side opened the door to this by in their briefing saying, look at the 2016-2018 analyses by the board. And one final point on this, Justice Baker, about the E standards, which don't have the narrative standards from 6371, for example, 1D, the narrative standard about aquatic life. Narrative standards are notoriously impossible to enforce because you get a situation much like this court analyzed in the Northern Cheyenne case where they're talking about water quality standards. At the end of the day, you look at the receiving waters and you say, wait, they're not supporting aquatic life for iron and for aluminum. But you have multiple dischargers. You've got the wastewater treatment plant, you've got the power plant, you've got the coal mine, and the end of the day is they say, well, we don't know who caused this. It's a multiple tortfeasor situation. We can't point the finger at anyone. So when you just have that very malleable narrative standard, it's not really much protection, Your Honor. And I submit that that's why they wanted to remove the stringent numeric standards, which are very easy to enforce.
So can you jump quick to the monitoring question?
Yes. First, the Clean Water Act requires monitoring at every outfall. DEQ acknowledges this, but then they say, we could monitor at every outfall through this representative sampling. We could tell from one representative outfall, say outfall 35, that there was such and such discharge at outfall 70. The problem with that argument is that DEQ in the record says, we don't intend this scheme to be representative. No one outfall represents any other one. The scheme is inherently arbitrary because they say it's representative, but then they say, actually, it's not representative. No outfall represents another one. The district court, in this point, they said the record just doesn't have any factual basis for saying that this representative monitoring scheme makes sense. And if you look at their citation to the record, they cite page AR90. There are just a couple conclusory statements there that say, well, it's generally the same kind of activity, and we think the outfall, the effluent is going to be similar. But when you actually look into the numbers that are in the AR, you see that pollution discharged from the representative and non-representative outfalls are very different to orders of magnitude. They don't discharge at the same regularity. They don't discharge the same quality of pollution. And there's no scientific analysis about what the conditions are on the ground there. And without at least compiling some data, at least analyzing some hard data, they can't make a non-arbitrary decision. And that's what the district court correctly found on that, Your Honors. If there are no further questions, I'd like to wrap up and then...
So your preference would be not using representative samples at all unless there's data supported. If they don't have the data, then they should be sampling all the outfalls.
We kind of have a two-part position. Our first position is they have to sample every outfall no matter what. That's the law of the Clean Water Act. Our second fallback position is even if that's not right, they have to have some science to show that these samples are in fact representative. The evidence in the record showed that it wasn't. In short, Your Honor, the district court's decision was robustly supported both by the law and the facts. It furthers the goals of the Clean Water Act and the Montana Water Quality Act of restoring the integrity of our state's waters and should be affirmed.
Mr. Gorder. You got 4 minutes and 30 seconds.
Thank you, Mr. Chief Justice. I'll be brief here. May it please the Court, Andrew Gorder for Coalition and Trout Unlimited. Because DEQ's ability to classify or reclassify state waters could have direct negative impacts on headwaters and tributary streams across Montana, the Coalition and Trout Unlimited appreciate the opportunity to give some additional context and perspective to the Court today. I just want to make a couple key points here. The first, I guess, is the scientific perspective on the importance of headwaters and tributary streams in Montana, like the ones affected by the DEQ's permitting decision in this case. And the second is the potential statewide impacts, not just to the environment, but to Montana's economy and issues of public health. Science is clear here. The health of a given watershed depends on the health of its parts, particularly its upstream headwaters. As our scientific understanding of these watersheds has grown, so has our understanding of the crucial role played by headwaters tributaries, which transcends their status as ephemeral or intermittent or perennial streams. Up to 80% of stream miles in Montana are either ephemeral or intermittent in nature. And I want to speak to this point because it was brought up by Mr. Martin. In the appellants, and I think it was the MEIC for the appellants, make the bold claim that Montana's ephemeral waterways do not support aquatic life, and they never have. This is just flat out wrong. To the contrary, intermittent and ephemeral waterways support a variety of aquatic life species and are critical to fish and wildlife populations, particularly in areas such as eastern Montana, where perennial streams are rare and widely separated. In western Montana, for example, if you have 10 species of fish in a stream, it's considered to be highly diverse. But intermittent and ephemeral prairie streams, such as those in eastern Montana, have been documented to contain up to 30 different species. Native species of prairie fish often wait for months in isolated pools of ephemeral streams for precipitation events, which allow them to migrate to other habitats. So given the importance that these tributaries play in the overall health of the watershed, industrial discharges to these streams can significantly degrade both the habitats, the wildlife they sustain, and as well as the quality of downstream waters. And I want to jump to the economic impacts here as well, because that was something that was raised by the MEIC for the appellants. Given the sheer number of ephemeral and intermittent waterways in Montana, it's clear that DEQ's authority to classify waters during the discharge permitting process would have far-reaching impacts, including impacts to Montana's economy. Healthy headwaters and clean water are the lifeblood of our largest economic sectors, which include agriculture and tourism. And they're also a vital part of our fastest-growing economic sector in Montana, and that is outdoor recreation. A recent study from Headwaters Economics found that outdoor recreation generates $7.1 billion in annual consumer spending in Montana. Creates 71,000 jobs. That's more than 10% of all of Montana's jobs. Anglers alone spent $919 million in Montana in 2017. And the overall outdoor recreation economy contributes $286 million annually in state and local tax revenue. This industry relies on clean waters and the regulations, much like the DEQ has abused in this case. Ensuring appropriate protections for tributary streams is also vital to ensuring protections for public drinking water supplies. We raised this example in the briefing, but 10 Mile Creek is fed by ephemeral and intermittent streams. This is an important component of the City of Helena's drinking water supply. If the DEQ were to do what it did in this case and just decide unilaterally in the permitting process that ephemeral tributaries to 10 Mile Creek can be downgraded in the permitting process and subject to lower water quality standards, those downstream waters are at increased risk of pollution. That affects public health. I'm going to wrap up right there, but I'd just like to say, the district court correctly held that a stream's classification cannot be changed without compliance with the applicable law. It must include scientific basis in the adequate public process. The district court's ruling on this issue is properly grounded in state law and should be affirmed. Thank you.
I'm just going to take a couple minutes. In the Clark Fork case, this court also said that an agency's interpretation of a rule is sustained so long as it lies within a reasonable range of interpretation permitted by the wording. And the plain language of 637.4 says that the specific water quality standards of ARM 1736-29 do not apply. And I also want to say that 637 sub 4 is a water quality standard, and it was also a board rule adopted by the board in 1980. In 2002, when the board undertook rulemaking to adopt the E classes, 637 sub 4 was an active rule on the books, and the board did not modify it in the 2002 rulemaking. And so DEQ's interpretation of the rules reads all the rules together, 1730-629, 1730-637-4, and the E-class rules. I also want to say that streams that have pools that hold water would not be ephemeral streams. And the water quality standards in 637-4 would protect aquatic life from acute exposure to toxins. I also want to say that the monitoring at the mine does require monitoring for iron, aluminum, and selenium, the three metals that MEIC pointed out. And also the permit contains a special condition so that if there are high levels, the mine has to do a toxic identification evaluation and undertake some action to reduce toxicity. So we're not just ignoring those metals. And then just to wrap up, in view of the record in this case, DEQ made a reasoned decision and lawfully issued the 2012 permit incorporating effluent limits and numeric and narrative standards that protect the designated beneficial uses of the receiving water based on 637-4, which specifically applies to ephemeral streams of all classes. And the permit also lawfully incorporated a wet weather sampling protocol that ensured samples and measurements are representative of monitored activity as required by state and federal law. Therefore, the district court's memorandum and order should be reversed.
I have a question, just following up on Mr. Martin's comment that this flexibility is so good because these permits only last for 5 years, and then DEQ has this ability to step in and kind of look at what's going on. So, but it took almost double the time to get this permit. So what's going on? I mean, that seems to counter this flexibility if we can't get another permit for another 10 years.
Yes, Justice, the mine applied timely for a permit renewal, and so their permit is administratively continued, which is allowed under the law. This is a large permit, and it does take time to write.
So would that be the expectation, though, in the future, is that they would apply timely again, and then it will take another 10 years, so really the 5-year permitting isn't really 5-year permitting?
Well, the permit is active for 5 years, but yes, sometimes the permitting process takes longer than 5 years, but we are looking at conditions at the mine.
So that process is a data gathering process. I mean, it doesn't just sit and gather dust. Something happens in that period of time before.
Right. There's a lot of assessment taking place at the mine, either as required by the mine permit or as required for issuing a new MPDS permit, and also our water quality standards. People are out there all the time doing attainment assessments. So yes, it's actively looked at.
And I assume all of that is part of the record in terms of issuing the permit.
Yes, in the record there are attainment records, for example, from our water quality program that support the ephemeral conclusion, the determination.
May it please the court, in the limited time I have, I'd like to respond to some of what my friend Mr. Hernandez said. First, let's talk about that portion of East Fork Mills Creek that is deemed impaired. Now, a closer reading of that impairment, it's a public document, and he's right, we kind of opened the door on this. A closer reading of that would demonstrate that, in fact, the elevated levels of iron and aluminum are from, quote, unknown sources and appear to be a product of natural causes. Just as that portion of East Fork Mills Creek to which we discharge, that is, Western Energy discharges in the ephemeral portion, is deemed to be impaired because of the lack of stream-side vegetation. It's not caused by the mine. That's caused actually by agriculture. So quite frankly, that's completely irrelevant to this particular inquiry. There is an argument out there that portions of these streams are not ephemeral. Well, if you look at the record, it turns out that in fact, to the extent that they are not ephemeral, they're actually outside of any purview of any discharge. And perhaps more importantly, it's a misinterpretation, if you will, of some of the documents. Without going into a level of detail to which I don't have time, I'd invite the court's attention to pages 10 and 11 of our reply brief. I'd also like to respond to the argument that this is a violation of federal regulations or federal law. That's simply not true, and it's demonstrably not true. In fact, EPA has reviewed these water quality standards. It's reviewed this provision of 637.4 for the last 39 years. There is a triennial review under the Clean Water Act. So EPA has reviewed these provisions and has recognized what DEQ does with respect to 637.4 and the C3 classification. They were promulgated at the very same time. They were approved by EPA. EPA has reviewed them, if I'm counting right, 10 or 11 times over the course of this time, and EPA has never said that it's non-compliant with the Clean Water Act. Finally, let me also add that this particular permit was in fact reviewed by EPA in 2012, and EPA accepted it, didn't reject it.
May I ask one last question? I guess I will. Thank you.
I need the time frame, I know.
Okay. Would your position also be, Mr. Hernandez said that the Clean Water Act requires monitoring of all outfalls. Is that...
That's, I think, misconstruing the regulations. That's at issue. And I would invite the court's attention to the Peabody case that was decided by the Environmental Appeals Board. It is true that we have to have representative sampling. We also have to have representative monitoring. In the Black Mesa case for Peabody, what happened is that there were 111 discharge points, outfalls. 20% of them were monitored. The EAB said that that was compliant with the Clean Water Act. So it's simply not the case that we have to have daily monitoring on each and every outfall. And there's a reason for having representative monitoring in this case. Many of these outfalls over this 26,000-acre mine are very difficult to get to. Bear in mind that the representative monitoring is only for precipitation-driven discharges. So when it rains, when it snows, there are many of these outfalls that people in the mine simply can't get to. And so what they did is they picked representative outfalls. And you can see from the record that this was done on a scientific basis, based on soils, based on discharge limits, based on expected contaminants. They chose the representative monitoring points. And this is the sort of thing. This is something that requires the application of DEQ's expertise, and I would submit is entitled to the highest level of deference. Thank you, Your Honors.
This concludes the argument. 180110. Thank you to all counsel. Much appreciated. We will take this matter under advisement and issue an opinion